who's present would like to speak. And if you don't want to speak, you can wave. Carolyn Stapleton.
Yes, sir. You just said my name, Carolyn Stapleton. Mr. Singfield won't remember me, but years ago when he prosecuted Derek Todd Lee, I was the Victim Services Director for the East Baton Rouge Parish Sheriff's Office. In fact, that was my first big case. We started with all of those people. I agree with everything you said, every word. So I started off with victims from law enforcement's point of view. I was at the crime scene. I went to the courthouse with them, and then I helped them with crime victims reparations. And then fast forward many years, I also served on the Crime Victims Reparations Board for 14 years. And in 2021, I stepped off. But in 2016, I got on the back end of all of this through, there was a grant through the Crime Victims Services Bureau for DOC. And I was the person chosen for that. And I was the liaison between Crime Victim Services and Probation and Pardons Board. And during that time, I saw some things that victims weren't even being notified that there was a probation or a pardon hearing coming up. So I'm going to quickly read to y'all something maybe y'all have already read, but a lot of victims don't even realize they have rights in the state of Louisiana. And then quite often they're not enforced because we have no enforceability capability for crime victims' rights. And our rights for victims say shall, but it's pointless because nothing can be done to anybody if they don't. But the second part of the paragraph for legislative intent and rights of crime victims, RS 461841, I think is very telling from a legislative point of view. The legislature declares its intent in this chapter to ensure that all victims and witnesses of crime are treated with dignity, respect, courtesy, and sensitivity, and that the rights extended in this chapter to victims and witnesses of crimes are honored and protected by the law enforcement agencies, prosecutors, and judges in a manner no less vigorous than the protection afforded to the criminal defendants. That is something that I would say many judges, many law enforcement officers, not all prosecutors, have even read and certainly don't abide by. And I know that firsthand from being a sergeant and being a victims person and then dealing with probation and parole. I've seen it from all points of view. One of the questions that I have here is if the new law goes into effect, have y'all considered that you say an accessory? I had two cases that unusually went to court. It was gang violence, and it was two cases of gang initiation. And in both cases, the person that pulled the trigger, one person, a young boy, was killed. This was all in Baton Rouge. And another one, the old man who was just walking across a parking lot, his face was shot off. He wasn't even able to make it to court. And when asked on the witness stand, why did they do it? They said simply, well, I was told to. It was part of the gang initiation. So you have that kind of thing going on. Most cases, gang initiations, you'll never catch the person who did it. But in this two cases, it was simply, I was told to. He pulled the trigger and he was told to. So that's something that has to be considered as what happens quite often, that you never find out who did it. We have a lot of cases in Baton Rouge. You never find out who did it because it's gang initiations. Secondly, truth in sentencing. A lot of victims are told quite often it's going to be a 20-year sentence, but they don't know that that's really not truth in sentencing because they don't know that somewhere down the road, and because I was the liaison with probation and parole, they get the opportunity after good time, after attending all their classes, to a petition for a probation or parole, whichever it may be. And here's the thing, when they get to do that, something that victims don't know either, and I saw, there's this nice little booklet that goes to probation and parole, and in it, it's bound on the side if they've had some help, and it shows each one of their pretty little certificates, okay, that they did. And then on closed circuit TV, you have their family, you have their preacher, you have their new wife that's married them, you have whoever's going to give them a job. Everything's nice and pretty and laid out. And then you'll hear a parole or probation board member say, I've heard this, in the most heinous crimes, well, I'm satisfied. He's done everything that we've asked him to do. There's nothing left to do. And that 20 years now may become 12, or that life sentence has been reduced to he's out. And then for the victim, what they're told to do is send in an email, sheet of paper. Or they have like what I have right here, and they're sitting in the audience, and they read this sheet of paper there, okay? We are not comparing apples to apples when we compare victims' rights to criminals' rights. I'm telling you right now. They're not even told they have rights. So when they go into many courtrooms, do you know, many courtrooms that I was in, that the victim and the offender's families and friends were mixed in together? That was common. It was first come, first served basis in a courtroom, and it could be the most heinous type of crime. Although we had a law that said court setting, and court setting was outside of the courtroom, and it depended on the judge. You talking about depending on the judge? It depended on the judge. Judges could assume it was outside the courtroom, that you keep the victim and offender's family separate. If you asked anybody what a court setting is, and they're just a regular Joe Blow like I was and anybody else, you're going to say the room where the judge is and the jury and everybody else. Nobody would think that at that point would be okay to mix family members of a victim with the offender's family. So do you see how awry this can go? Because I went into courtrooms, and when I did, I went in with the law. And I would hand it to the prosecutor if I thought something wasn't going to be done from a victim that should be, or if it was the judge and I wasn't going to get courtroom seating like I thought that my victims deserved. And in most cases, in Baton Rouge, judges would just, after I'd pass up that law, which they weren't aware of, they would put a sign behind the prosecutor's desk, and it would say reserved. So see, I knew that my victims were going to be taken care of, and the other side was going to be for the offender's family. That's common sense. But let me tell you what, I did run into judges too, that you know what they said? My courtroom, if you don't like where you're sitting, you may as well walk out the same door you came in. But I addressed that. I did. I addressed that with legislators. And I addressed the fact that I had a victim. You talking about victims? Him and his girlfriend were kidnapped, victims of armed robbery. The girlfriend was brutally raped. One of the guys told the juvenile shoot him, shot him twice to kill him, and he ended up living. So we fast forward years later, and it's going before probation and parole. And unbeknownst to me and everybody else that I know, probation and parole, we have a law that says if you have filled out the Louisiana Victim Notice and Registration Form, you shall be notified of all hearings. And that goes all the way through to DOC. But I didn't know, because I had a victim that called and said he was told he wasn't a victim. And when I checked into it, probation and parole had added a little sentence that said, only for the victim of the crime of conviction. And I said, no, that is not our law. And I said, that's a plea bargain. And so see, some of these second-degree murder charges, they can be plea bargains too. They could be manslaughter and stuff like that. Plea bargains happen all day long. So what I'm wondering is, if you lower this to 20 years, are you going to continue that the It's going to be without suspension or probation or parole. Are you going to continue that wording, 20 years without benefit of probation or parole or suspension of sentencing, just like you have for the second-degree murder? That's what I'm wondering about that. And then I'm wondering also if it's going to be retroactive, or if it's going to start from the day of the law is passed, from that day forward, or are you going to go backwards and make this retroactive to people who's been, because like the Supreme Court, this case here, that was a juvenile lifer, so he got the opportunity to come before the parole board because it was made retroactive. It was overturned. And so victims leave out of a courtroom and they think, okay, life, I'm never going to have to deal with this again. It's over with. Or 20 years. I was told 20 years. I'll never deal with this again. So from a victim's point of view, they think they're finished with this for whatever time they're told, and they're not. They're not. It comes back and haunts them within 12 years, sometimes 7 years, and they're like, where is this coming from? And then if they weren't even told they had the right to register as a victim, they're not even in the system because we have an opt-in system. And unless you have a very vigorous prosecutor or law enforcement service victims bureau, victims quite often are not told to fill out that form, so it doesn't follow the offender all the way to DOC. So do you see where victims fall through the crack here?
No, I understand. I have maybe 2 or 3 comments here. First of all, this is not retroactive, okay?
Okay.
Now, I do know that we have other laws that are not retroactive, yet people still file suit. I get that.
Yeah.
And that's a problem. I understand that too. But I don't want to make it retroactive, but the DAs will get lawsuits no matter what because people are going to still sue and try to circumvent this retroactivity part of it. That's part number one. Part number two, again, I know you know, but there's no law here. We're trying to determine if there's any room to possibly bring a law, okay? If this committee cannot agree on anything, then no law will be brought, okay? So there's no law right now. Whatever you see or you read, that's just something that, I don't know what it may be, because the only thing you should be looking at is the resolution that says why we're here. The third thing is you mentioned people that had life with parole and they got it changed smaller and smaller. Again, we're talking about people that have life without parole, okay? We're trying to make a distinction on some of those people that have life without parole, making some of them have life with parole. That's at the crux of this.
And that's where the problem's going to come in. Life with parole, that 20 years is not going to be 20 years. It's going to be maybe
it could
12.
be, and it could be a judge's discretion. I mean, I don't know that, but you have that in the system already. Okay, I mean, you have life with parole, and they reduce it all kind of different ways. I mean, I have a friend of mine that should be out, and they're not giving him parole, and he didn't kill anybody. Okay, so I mean, we can go on. We have examples all over the place.
Man.
We're trying to address some of the possible exceptions, and maybe it can't get addressed. Okay, but we have to try, and that's the purpose of this committee.
Well, you heard what I said about victims' rights. You heard what I said about some situations where they were overlooked. And then you also heard what I say. I'm 100% behind everything that Mr. Sinkfield said.
Yeah.
Thank
Okay.
you.
Thank you, Ms. Stapleton. Okay.